Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are turning our attention to a trial out of Georgia. Sarah Grace Patrick is set to have jury selection start today. There is some definitely some weirdness coming out of the court, so we're going to take a look at that. And while the jury is being selected, we're going to look back at some of the hearings that we missed the past couple months. So it's not going to be a long stream. It's only going to be a couple hours as we wait for jury selection, and then we'll talk about the court order about streaming. So settle in, get comfortable, and let's get started. All right, welcome in, everybody. Welcome in. So, Georgia versus Sarah Grace Patrick. There's been some really strange things going on with this trial. Defense is asking for continuance. The judge ordered a very bizarre ruling. Amended July 7th. No person or media outlet shall stream or broadcast audio, underline audio, of the proceedings, transcripts of the audio, or images of exhibits until further order of the court. No person or media outlet shall stream, broadcast, or publish videos, audio, or still images of any potential juror, or minor child witness. Now that's fine. Obviously, don't want the jury to be videoed and or photographed. But the first one is very strange. So then we heard that cameras would be in court, but then the latest update, which was 13 minutes ago, jury selection starts today. The judge issued a bizarre media order last week ordering video only for the trial, no audio. Yes, you read that right, no audio of the trial. We had a media attorney contact the court. We've been waiting to hear back. Hearings, and we're going to show her hearings, and we did a deep dive earlier this year, or was it? Anyway, it was like either December or January. I think it was December, because her trial was supposed to start in January. Those hearings have audio and video, and the hearings we're going to show today have audio and video. Then in the last hearing, the defense asked for a delay, which we'll show that. The judge issued a rule under seal. But we were told the trial was still going forward today, and then the weird media order was issued. So we are going to have to see, we're going to do our deep dive regardless, because, it's still something that we can talk about, and we do have video and audio of her hearings. So we are still going to continue with that. I tried calling the news station and did not get any information from them. Actually, it said nobody was there to talk. No one was there to talk. So we're just going to keep an eye on it and see if, I don't anticipate a jury to be seated today in any event. That's why we're kind of doing a deep dive. So anyway, all right, so let's get settled in, guys. Hell Rider, how are you? Good to see you. Welcome in. 80s Music Man, Scroobnick, Crazy Mary Fitz. Hola, how are you? Kimbers, good morning. Ladybug's mom, good to see you. Camilla, YT Hazel. Let's see. We have, who else is with us? I know a lot of you are here. Let me just scroll up to when we actually started. Ed, how are you? Let's see. Kaylee, hello, welcome in. Crazy Mary Fitz. Green-Eyed Cat. Kimbers, good vibes. Good to see you both. Hey, Snap, welcome in. Debbie, good morning to you. Bing and Billy, Sweet Vampy, good to see you. Welcome in, guys. William, have a good day at work. Great to see you. Grizzly Grandma, good morning. Banana Pants, how are you doing? Hey, Iowa, great to see you. Tammy and KS, Crazier Cat. Lori, good morning and welcome in. Snow Cattish, Jenny Tonic, hello, good morning. Bama Green Eyes. Snake Lady Dot, hey, Gracie, how are you? Welcome in. YT Hazel. Cindy, good morning. Welcome in. Hey, Jackie, just finished watching part 1. Cool, well, we're going to get to part 2 in just a moment. All right, I think I got everybody. Let me just make sure. Shelly Beans, good morning, Regina. Great to see you both. There's Hellrider. All right, I think I caught up with everybody. All right, here we go. Hey, Scott Trial Watcher. Good morning, Linda. Good morning. Welcome in. Christine Fortunato. Hello. All right. So I told you there is a weird court order. So we're just going to have to wait and see. I don't expect a jury to be seated today anyway. So we were going to do our deep dive regardless of this court order. So we'll see. We're at least going to get you guys up to speed with the trial, and then I should say the case. And then if it's streamed, we'll pick it up. And if it's not streamed, we'll move on to something else. All right. So date of the incident, February 20th, 2025. Sarah Grace Patrick is the defendant. She is 17 years old. The victims are Kristin and James Brock. They were 41 and 45 respectively. Sarah is charged with 2 counts of deletion and 2 counts of aggravated assault. The judge is Dustin Hightower. Her defense was Latoya Williams, but that's changed. She has a new defense now. And the prosecution is Michael Parrish. All right, so on February 20th, 2025, Kristin and James Brock were found shot to death inside their home in Carroll County, Georgia. The couple was discovered in their bedroom, and authorities determined both had passed away from gunshot wounds. The victim's youngest child, 5, reportedly discovered the scene, and Sarah Grace Patrick, their teenage daughter, contacted 911. Now, they were together for nearly 10 years. The couple was raising 3 children in a blended family and were active members of their church community. According to the authorities, there were no signs of a break-in, and nothing was missing from the couple's house. For several months following this, the case remained unsolved, but then on July 8th, 2025, investigators arrested Sarah Grace Patrick, who voluntarily turned herself in after warrants were issued. She was 17 years old at the time of her arrest and is being charged as an adult. Now, she's also, what caused a lot of stir was that she did this eulogy for her mom. It's her mom. Dad is, James is their stepdad. So her mom is Kristin. And she went on TikTok, and we'll show a little bit of that, where she was just breaking down, hysterical, missing her mom, and having a really tough time of it. So we'll explore all of that while we look back at some of these hearings that we missed over the last couple of months. All right, so let me get us over here, and we will start with. I'm going to start with a couple news clips, kind of outlining what happened, and then we'll get into hearings that we did not show in our part 1 deep dive. So first of all, let's just kind of set the scene. In case you guys did not watch part 1 or you have no idea what this is about, we're just going to kind of set the scene a little bit.
Tonight, police are still looking for the person or people responsible for gunning down a couple inside their Carrollton home. The Carroll County Sheriff's Office says deputies found the husband and wife early Thursday morning. Our Chase Howell is in the newsroom tonight after talking with the couple's family. And Chase, they were actually kids inside the house when all of this happened. Do they have any idea here why someone would do this?
They don't. I mean, there was nothing taken from the home. There wasn't any forced entry. And according to the family, they had no enemies.
It hurts to know that somebody would walk in their house and shoot them
Held tight in Dennis and Linda's hands is a picture of Kristin and James Brock, the two found shot and killed in Carrollton early Thursday morning.
You know, if it was of natural causes, you would maybe feel differently, but to go this way, it's really tough.
Dennis is Kristin's dad. He says his daughter and James have been together for close to 10 years and were raising 3 kids. The 5 and 16-year-old waking up to find both of them shot to death in their bed.
She went into the bedroom, and because she, I guess, assumed that my daughter Kristin would have been up by this time, and she went to wake her and she grabbed her hand, and she said her hand was ice cold, and looked a little further and realized that she was deceased, and she dialed 911.
Dennis says this whole situation is bizarre. He says the two were extremely active in their church, and James was waiting for a heart transplant. And not just that, but nothing in the house was missing, and there were no signs of a break-in.
If there was something they wanted in the house, they could have taken it, and they probably would never woke up. But for some reason, they wanted them dead. And I want to know why.
Since the shooting, Carroll County deputies have been at the house nonstop, trying to piece together who killed Kristin and James.
He told me they're going to, if they have to turn over every blade of grass in the yard, they're going to do that to find something to go by.
Now, for those of you who may be just learning about this, the Carroll County Sheriff's Office has ruled out murder-suicide. So that means investigators believe the two were murdered. And right now, the Nolan family is offering up a $5,000 reward for any information that leads to an arrest and conviction. Cheryl?
Chase, thinking about the family tonight. Thank you so much.
All right, so that kind of sets the stage a little bit. Here they are talking about that reward. And again, if you're just joining us, there is a court order that says no audio. No audio.
Now at 4, a family of a murdered Carroll County couple now offering a reward.
Sorry. No audio in the court, but there is attorneys are fighting that for media. Media companies are fighting that, and we're just waiting to see. Jury selection starts today, I think, regardless of whatever this court order, if it stands or not. I don't think they'd seat a jury today, and if they would, it wouldn't be later today. So I have a feeling they're not going to. They wouldn't have a jury. They wouldn't start opening statements today. I could be wrong, but that's why we're doing this deep dive. But attorneys for the news stations are fighting that, for the media, are fighting that court order that Judge Hightower set, amended back in July 8th, that video was allowed but no audio. So again, very, very bizarre ruling, but we're going to keep walking the path with our deep dive regardless, because it doesn't matter. And then if they seat a jury and they start streaming, we'll pick up on it. And if they don't, we'll move on to another trial. But that's kind of where we stand with it.
Now at 4, a family of a murdered Carroll County couple now offering a reward for any information leading to the couple's killer.
Atlanta News First Yasmin Alston is live at the Carroll County Sheriff's Office with more on this case. Yasmina.
That's right. That family offering a $5,000 reward for any information leading to an arrest in the murder of James and Kristin Brock. They were sleeping in their bed when they were killed.
This is so horrendous. You just can't imagine that someone would come in and just take the life of 2 good people.
Sitting in his home, looking at pictures of his daughter, Dennis Nolan is still in disbelief.
And his first words were, Kristin and James are dead. And I just couldn't believe what he was saying.
Nolan's daughter, Kristin, and her husband, James Brock, were killed in their Carroll County home last Thursday from apparent gunshot wounds. As of Monday, their deaths remain a mystery.
Why would someone want to do that? And they didn't steal anything. There was nothing of value in the house. They weren't into drugs that I know of, that I'm aware of. And to get someone that mad at you to come into your bedroom and just cold-heartedly, murder, and don't understand. I need closure on it.
Nolan says Kristin and James were sleeping in their bed when their youngest daughter discovered their bodies at the home on Tyus Carrollton Road. This tragedy leaving the family devastated and desperate for answers. Nolan even offering a reward for information.
There are people out there who know. They need to come forward, and they can do it anonymously, and they can get a $5,000 reward and get this person off the streets.
Nolan held back tears as he scrolled through his last text messages with his daughter. One of them was Kristin saying she loved him.
We were very, very close. She loved me with all her heart, and I did her.
And investigators say this is still a very active investigation. If you have any information, you're asked to contact the Carroll County Sheriff's Office. Live in Carroll County, Yasmina Alston, Atlanta News First.
All right, so again, for you guys that are just joining us, the latest is jury selection starts today. The judge issued a bizarre media order last week ordering video only for the trial, no audio. So media attorneys have contacted the court. So we're just waiting to see. We're waiting to see. Jury selection does start today. And in any event, I'm not anticipating them seating a jury in one day. So we are just moving forward with our presentation here. Regardless of whether or not they stream it. So we certainly hope that this will. I guess it'll be streamed. It's just going to be no audio, which again is very bizarre. So I don't understand that. I don't understand that ruling, but that's what has happened for now. So we're just going to keep moving forward and presenting our information. We do have a couple hearings that we did not watch yet. We have a part one that we did watch, some hearings from last year. A couple new hearings happened this year, so we're going to show those in a little bit. But first, we're just kind of setting the story, understanding what happened.
A 17-year-old is now charged with murdering her mother and stepfather in Carrollton. Investigators say Sarah Grace Patrick is the one who killed James and Kristin Brock in their home in February. Channel 2's Candace McCowan is outside the jail where the teen who is being charged as an adult is being held now. Candace?
Yeah, and Wendy, this is tragic no matter how you look at it. From the couple's 5-year-old daughter who is said to have found their bodies to the 7 children that the couple had between the two of them and their combined family. Now those 7 children, each without one of their parents. And one of those children is now behind bars here at the Carroll County Jail, charged with the murders.
The beginning of any case, everyone's a suspect. From the very moment the 911 call was received, a relentless investigation began.
And it is the person who called 911 who is now charged with the shooting deaths of James and Kristin Brock in their home on Carrollton Tyus Road in February. 17-year-old Sarah Grace Patrick is now charged with 2 counts of murder and 2 counts of aggravated assault in connection with the deaths of her mother and stepfather.
She turned herself in because we notified her she had warrants for her arrest.
Investigators say the evidence led them to charging the teen, including the speech of Sarah speaking at her mother and stepfather's funeral that's posted on Facebook.
Although there's nothing we can do to bring them back, we still have control over how we treat people.
And they say it's part of her covering up what happened.
Considering that she didn't just immediately tell us what happened, yes. But who knows what's going on in a young person's mind like that.
And while there's been a more than 4.5-month wait for an arrest, investigators say it took time to build the case.
Don't you want the right person arrested? So that's why it takes so long. These diligent investigators took their time. We've got the person that we believe orchestrated this and committed this horrific crime.
And I asked investigators today if there had been any prior calls with law enforcement to that house between the teen and her mother and stepfather. They said that there had not been any. They are still working to figure out exactly the motive here. For now, live here outside the Carroll County Jail, I'm Candace McCowan for Channel 2 Action News.
All right, they're still trying to work out the motive. So now let's get to that press conference. I'm going to get to this press conference of her being arrested. And then we'll get to some hearings from this year that we have not watched yet. Let me just move myself over here. This will be better over here. Okay.
you all remember, I recognize many of you in this room that did come out on the scene that fateful day on February 20th. On the morning of February 20th, 2025, deputies with the Carroll County Sheriff's Office responded to a tragic scene at 1531 Carrollton Tyus Road. They discovered the bodies of James Brock, 45, and Kristin Brock, 41, both deceased from apparent gunshot wounds. From the very moment the 911 call was received, a relentless investigation began, one that would span months, consume thousands of man-hours, and require the full weight of the local and federal law enforcement agency partnerships. Today, we can confirm that an arrest has been made in the case. Kristin Brock's 17-year-old daughter, Sarah Grace Patrick, has been taken into custody and charged with 2 counts of murder and 2 counts of aggravated assault in connection with the deaths of her mother and her stepfather. While the case has not remained in the public spotlight in recent months, the investigation has never gone silent. Led by investigator T.J. Rapetto, our team has pursued every lead, sifted through mountains of physical and digital evidence, conducted countless interviews, and collaborated with agencies such as the FBI, the GBI Crime Lab, and private forensic laboratories. In a world where television portrays crimes being solved in under an hour, the truth here is much more complex. Real justice takes time. Time to ensure that no detail is overlooked and no stone is not turned over. Sheriff Terry Langley, alongside Captain Guy Pope and Lieutenant Jackson Lawrence, has remained committed to ensuring that justice is served in this heartbreaking case. Their leadership, combined with the tireless dedication of our investigators, has brought us to this point today. We know the public has been eager for answers, and we want to be clear. So have we. But bringing forth the truth responsibly and thoroughly is our highest obligation. We are proud of the unwavering commitment shown by every member of the Carroll County Sheriff's Office, and we stand behind the process that has led us here today. Our prayers remain with the families of James and Kristin Brock, and especially with their young daughter who was home during this horrific crime. We also want to extend our heartfelt thanks to the community that has rallied for justice and has never given up hope. The pursuit of justice does not end today, however. It is very possible, because this remains an open and ongoing investigation, that more arrests and charges could be made. So with that, I will open this up to questions.
Has she been charged as an adult?
She has.
And any idea what her motive was when she gave the confession?
We are still working with her diligently. Our investigators have been speaking with her.
It is correct that she was the one who made the 911 call, correct?
Yes.
At what point did investigators begin to focus on her as the suspect?
So I believe in the beginning of any case, everyone's a suspect. I think I told many of you that when we were on scene that day. However, as an investigation continues and everything ebbs and flows, like I said in my press release, mountains of evidence has gotten us through here today. Lots of processing, lots of working with our law enforcement partners to get us to where we are today that honed in on her as a suspect.
Do you believe that she tried to cover this up in any way over the course of these months? You know, we've even seen some videos on social media of somebody saying, you know, I'm making this message on behalf of the daughter. Do you believe she tried to get people to cover up anything?
Considering that she didn't just immediately tell us what happened, yes. But who knows what's going on in a young person's mind like that. But she has been arrested and charged now, and we feel confident that she is responsible for their murders. But like I said, it is an open, ongoing investigation. It's very possible others are involved as well.
What was the key break in the case?
Just evidence, being able to go through evidence, being able to use private laboratories, being able to use GBI Crime Lab. You know, when you're processing stuff, like I said, it doesn't come back in an hour. So we've been filtering through, and there's still evidence left to process.
You noted the digital evidence. I assume that's text messages, emails. Was there some type of a trail that led you that way?
There's always a lot of evidence. I won't go into exactly what it is because it is an open, ongoing investigation, but we have mountains of evidence.
What about the social media and TikTok, that type of stuff? Any of that going to be used?
That will be up to the prosecuting attorney, and they'll work diligently with our investigators to make the case go forward towards trial or whatever they decide to do.
Was that the younger daughter, the youngest child that found them?
I believe that, and you speak to this, Kim, the smallest daughter found them that morning, correct? And then she came and told Sarah, and then Sarah made the 911 call.
Where was Sarah?
Sarah was in the home.
No, I mean, in the interim. Where was she staying? Who was she living with?
She's 17. She's kind of been out on her own.
Was she out on her own at the time?
No, she lived at home with her mother and stepfather at that time. But since then, she's lived with different family members and kind of moved all over the place.
Did she turn herself in?
Yes, she did turn herself in this morning.
Do you believe that any of the other family members knew about this?
Hard to tell. I can say this, that everybody that we have talked to through the course of the investigation that are family members have been nothing but cooperative. Anything else?
Did you do anything after the murder during the investigation that you guys will use in your
Like I said, we're still kind of putting all the pieces of the puzzle together, but I can tell you what led us here today, and that's the evidence that Sarah killed her parents.
Did she say why she turned herself in?
She turned herself in because we notified her she had warrants for her arrest.
Did you give previous charges, any previous calls to that house regarding?
Not that I'm aware of, not regarding her, not that I'm aware of.
Did she seem remorseful?
I have not been personally with her or interviewed her, so I could not answer that question.
I think that was a shock to her family as well. Did you get any kind of, were they shocked? What surprised them?
Like I said, her family's been very cooperative. I can't imagine as a parent her father brought her up here this morning. She turned herself in. I can't imagine what he's going through, so my heart goes out to him as well.
You talked about the family. I know they've been trying their best to keep this in the forefront.
Yes.
I know you guys are working behind the scenes.
Yes.
I guess it takes, especially for a case this big, it takes a lot of time to make sure the I's are dotted and T's are crossed. And you speak to that because they've been seeming like on social media that they were frustrated, but it takes a lot.
Yeah, and we understand. I mean, if you don't work in the law enforcement field, like I said, CSI's kind of tainted us where, hey, something happens, it's done in an hour. This is not the case. I mean, and not only that, don't you want the right person arrested? So that's why it takes so long. These diligent investigators took their time. We've got the person that we believe orchestrated this and committed this horrific crime, and that was played through the part of evidence, and that's not something that's processed overnight.
Do you know where the weapon was obtained from?
I can't speak to that right now. Still investigation. Say that again?
The younger child, how old is she?
She is 6 years old now.
Do you have custody of her?
She's staying with family.
Can you speak to like just how she gets this?
Oh, it's absolutely a shock to our community. Carroll County is a great community. We very rarely have stranger-on-stranger crime here, so I would like to say that we're not a dangerous community. I know that the Tice community that this happened in, those neighbors were really up in arms, as they should have been. Like I said, this has been a process to get us to where we're at today, but we don't know what goes through the mind of a child who wants to harm their parents. So that I can't answer right now, but it is a very horrific and sad case.
Was there any evidence of any type of I don't want to say abuse, but challenges in the home?
Still an ongoing investigation.
And for anybody who worked on this case, I don't know if there's ever been any other case like this in any of your careers, or if this is one of a few. But just when the facts, as you say, lead you to this conclusion, is it difficult, or what is that like just as a human, kind of when you follow the facts?
Anytime you work a case where somebody's life has been cut short, James is a special case because I believe, according to his family, he had a lot of heart trouble. He'd had numerous heart surgeries. I believe he may have been waiting on a heart transplant at some point. And to have his life cut short when he was given so many opportunities to live, to me, that's a big takeaway from this story, and that a mother and a stepfather will never be able to raise their children and the little girl that was in the home. To me, she's probably the saddest victim in all of this.
You did mention she didn't turn herself in. You said she was turned in with her father.
Yes.
Correct?
Yes.
Okay.
Mm-hmm. All right. I'll be around after if you have any additional questions. I will send you, if you will give me a business card, I'll be happy to provide you with my press release and the mugshot. Just let me know if there's anything additional after this that you may need. Okay. Thank you for your time. I appreciate you coming out.
All right, well, we heard some good information there. The 6-year-old, now 6 years old, found the parents. Then we have, found the parents. We have James was looking for a heart transplant, so he had some issues there. Sarah Grace was 17 at the time. She's now 18. Her birthday, I posted that her birthday is April 28th. So she is now 18 years old, and she will be charged as an adult. Even back then, they were saying she was going to be charged as an adult. All right, so some family members are standing by her while others are not. So let's get over here. This is a clip of a family not standing by her.
So for the first time tonight, we are hearing from the family of Jamie Brock. That's the man authorities say was allegedly shot and killed by his stepdaughter in Carroll County.
Along with Brock, 17-year-old Sarah Grace Patrick is also accused of killing her own mother, Kristin Brock. Our Chase Howell has been on this story from the very beginning and asked the question on everyone's mind here: why would this girl want to allegedly kill her mother and stepfather?
Family of Jamie Brock say this is Oscar-worthy acting by his stepdaughter, Sarah Patrick.
It's weird. And the TikToks kept getting more weird as time went by.
Kristin Dowda is Brock's niece. She says she always suspected Patrick of killing Brock and her own mother, Kristin, in February. Why do you think she allegedly did this? I mean, why would this 16-year-old girl, who people have said it was a sweet, kind, in your own words, a sweet, kind girl, despite what Jamie told you over the phone, would want to kill her mother and her stepfather?
Anybody that's ever been a teenager, you know that you get mad at your parents and you don't like what they say, and maybe they were too strict, and maybe that's what she thought. But, you know, anybody that's ever been in that situation and you've been mad at your parents, what you didn't do is you didn't kill them.
And while Dowda won't speculate on a motive, she thinks it is possible Patrick didn't act alone. But as of Wednesday, no other arrests have been made. Reporting, Chase Howell, 11 Alive News.
We did reach out to the Carroll County Sheriff's Office for an update on its investigation, but as of now, there is no new information. Ahead tonight at 6, Chase addresses allegations that have been made against the Brock family.
All right. So now the motive, that seems that perhaps there was something going on, that maybe some assaults. You know, we'll have to wait and see. All right, now here's where I'm going to play. This is where it gets into her posting on TikTok. I'm not going to play all of this, but I'm just going to play a little bit of it here and there.
I have more to tell you.
All right, so this is obviously from Law and Crime on the Case. So I'm just going to play a little bit of this because this is where it gets really, I know a lot of people have issues with this.
Regarding the teen girl who was arrested this week for allegedly killing her mom and stepdad in Georgia in February. Her name is Sarah Grace Patrick, and she didn't just post on TikTok mourning the loss of her parents, she did a lot more.
Why would you ask me to cover a case where you are going to get arrested for taking your parents' lives?
It turns
So here she is. She's asking she's asking a content creator, a true crime content creator, saying, you know, just contacting them. It's really weird.
She also reached out to several crime creators on TikTok, encouraging them to look into the case. One of those creators is going to join me to talk about what Sarah Grace Patrick told her and the chilling comments she left on her account that you just have to see. We're on the case, presented by Law and Crime. As they lay in their beds in the middle of the night on February 20th. Now, Sarah Grace was also the one who called 911. And not only that, she says that her then 5-year-old sister found her parents, Kristin and James Brock, shot dead. Just think about that. Sarah Grace also claims that it was her little sister who then alerted her, and then she alerted the authorities. But now we know that was allegedly a lie. Sarah Grace posted this on TikTok saying the loss of her parents hit her when, quote, "I see my 5-year-old sister screaming, crying for her mommy and daddy." I can't say it enough. Sarah Grace is the one who is now charged and accused of being the person who killed that little girl's mom and dad. Sarah has also posted about needing help with her mental health and needing to call a hotline for that and being depressed. So we are working to learn more about her.
So I guess the question is, what's the story here? Was she faking that? I mean, let's check this out.
Someone could take her mom and stepdad away, people who she loved so much. She was a regular commenter also on posts and stories related to the murders that she allegedly committed, accepting plenty of thoughts and prayers. You can see on this one, she replies less than a month after she allegedly killed her parents with, quote, "I love you, thank you." On top of that, Sarah Grace spoke at her parents' funeral at their church. This is per WSB TV.
Although there's nothing we can do to bring them back, we still have control over how we treat people.
But we have found it goes deeper than that. She appears to have taken the initiative to reach out to TikTokers who cover true crime, encouraging them to research, report, and talk about the murders that she is now accused of committing, as if she was someone looking for justice for her parents.
Y'all, this is Sarah Grace, and she messaged me back on June 3rd and just said, "Search up Brock case."
This is the account called Allegedly Reportedly. It has more than 130.
So if you guys don't know, Allegedly Reportedly, she does really good work. She's on YouTube as well. I think she was actually talking about this case. So if you guys don't know her, definitely go check her out. But just very, very, very bizarre. Just kind of scrub through a little bit more.
On TikTok about her parents, like this one on Mother's Day. She also would post images as if she was continuing to live her life. It was just a week ago. She posted this from what appears to be a trip to the beach for the 4th of July. Deputies say even though Sarah Grace was 16 at the time she killed her mom and stepdad, she's now 17 years old. She is facing charges as an adult. She is facing 2 counts of first-degree murder and 2 counts of assault. Another part of this story that we're watching is deputies say that more arrests are possible in this case. Joining us now to talk more about this case is one of the creators on TikTok who Sarah Grace Patrick
Sorry, I know, I was muted. Sorry. I know, sorry, guys, sorry. Thank you. Okay. Let me rewind it. Okay, so I don't know, Jane, I don't know if Allegedly Reportedly is on Facebook. I know that she's on YouTube, and then obviously TikTok. So, and it's like, those posts on TikTok, it's like, with all the makeup and stuff, it's like, does that come across to you guys as, is that like genuine? I understand grief is grief, but to show people that side, is it just for clicks? Is it for views? Is it for attention? Is she trying to get some kind of sympathy? Why would you do that? Just publicly show you at your worst, maybe it's a generational thing. Maybe it's a social media thing. I don't know. But she clearly was comfortable with exposing herself and showing herself at the worst of the worst, Hey, Elaine, how are you? Welcome in. All right. So now we're going to get to this year. So if you watched part 1, this is pretty much where we left off with part 1. So now we're going to get into part 2 and show some of the hearings from this year. Now, here's what I don't understand. This is Judge Hightower, right? So he allows audio and video in these hearings, but then he issued this court order that it's only going to be video only. So we're still trying to sort that out. I know the media has some attorneys there trying to fight that. So we'll see where that goes. All right, so this is from January 5th. This is it being delayed. Remember, it was supposed to start in January.
Patrick, defense, your announcement was ready. Is that correct?
That's correct, Your Honor.
All right, and state, I believe you have a motion that you want to do. Before we get into that motion, let's bring Ms. Patrick out, okay? Yes, Patrick, just before you came in, we're calling through the trial calendar, okay? All right, on the trial calendar, your attorney has announced ready, and the state says they have a motion, so we brought you out so you can be present for that motion, okay? All right, if you have any questions along the way, that's what your attorney's there for. If you have questions that your attorney can't answer, she knows that she can reference those to me, so just make sure you speak with your attorney, okay?
Yes. Okay.
All right, Ms. Weeds, we good?
We are, Your Honor.
All right, state.
Thank you, Judge. At calendar call on December 16th, Ms. Williams and the state both indicated that the report regarding the psychological evaluation or the neuropsychological evaluation was not back yet. On December the 31st, we did receive a preliminary draft of the report from Ms. Williams, but as of right now, we still don't have the final copy of that draft. And after just reading the preliminary draft, the state does believe that we need to evaluate that to retain our own expert in that matter. So at this point, because of that, like I said, on December the 16th, we might need to evaluate that for an expert report. The state is going to be asking for a continuance in this matter.
Your Honor, we are opposed to a continuance. We are asking that the court would let us go forward. I had indicated that we would get that report shortly after that court date. As soon as I got it, I did forward it over to the state. But we are ready to proceed despite, having the preliminary report. We anticipate that I would have the final draft of that report and have it over to the state by the end of the week, and I think we can go forward.
But Ms. Williams, you're not even in possession of the final report at this time, is that correct?
That's correct, Your Honor.
The state, your argument is that even on the preliminary report, for y'all to adequately present your case, you need time to have an expert look over their expert report, is that correct?
That's correct, Judge. When we go over the preliminary report, without getting into the preliminary report itself, there are some issues that the state does believe that we need to at least evaluate to get an expert report in that case to rebut their expert. And again, and I know Ms. Williams doesn't, but the state still doesn't have a final copy of that report, and today would be the start of her trial.
Before I go too far, I want to compliment both defense and state. Anybody who is in the legal system knows that I put a very rigorous schedule on each of you. To have a alleged double homicide case ready within 4 to 5 weeks is lightning pace. And y'all both, state and defense, have done a phenomenal job. Y'all have had conference calls with me regularly. Ever since that date, y'all have kept the court well informed of where y'all are at, what was needed, and what was going to happen. And y'all have done that even for today. We've had multiple conference calls before this hearing. We all kind of knew what was going to eventually transpire today. That's because of y'all's diligent effort. And so, Ms. Williams, thank you. State, thank you. Ms. Williams, I do not believe that the delay in this report is a tactic or a fault of yours at all. I think that expert reports, from my own experience, they take time. And just the time frame that I laid down for this case did not give your expert enough time to get things done in a matter of time to give the state what they needed to do. While I know that you're saying you're ready, I also know that you need that full report, and you don't have it. I think that you're weighing that against saying that your client's in custody and you want to be ready to move forward for her best interest, but I also know that you want that full report as well. For you to get that full report a week from now or 2 weeks from now in the middle of trial, and the state to get that report for the first time at that point and then decide they need an expert, I do not think that would be fair and just for either side. And we've had that conversation candidly and honestly with each other during conference calls. So even though I'm very reluctant to give a continuance in this case, I do think that it would be appropriate. With that being said, I don't want this case to languish. I still hold by what I told Ms. Patrick at the beginning. I don't want her to sit where she doesn't need to sit. That's not where she's supposed to be. And only the facts of the case will let us see that every day. In order to get there, I got to try this case. So, I have dates. I have a trial week that can handle this type of case in March. I have one that can handle this case in May, and I have one that can handle this in August. Now, you both know what's really there. Ms. Williams, you know the true ins and outs of your side and what's really needed. State, I think you're starting to see, based on this report, what you may actually need. Realistically, from each of you, when can y'all tell me we can be ready by this date and this case not have to be moved?
Judge, from the state's perspective, I think the best date would be that August date for everyone. That seems to be a date that will match up with what our needs are in terms of coverage for other courtrooms, as well as just the opportunity for our experts to prepare to combat any and all defenses as presented by Ms. Williams in the defense.
Ms. Williams?
Your Honor, I think that August would probably be the best to fit the court's need of not having to move it again. Realistically, I think that maybe if we said, March, we probably would be back here at in the same position to say, hey, maybe we need a little more time. So I don't often agree with the state, but I will say August would be the best bet if we're trying not to come back here and have the same announcement.
So, I don't like setting cases just to set them, which is why, in all candor, it'd be easy for me to sit here and go, let's place this on March, but know in the back of my mind, March is not going to be a realistic date. So with that being said, we go with August. State, you're saying August. Defense, you're saying August. Are we all under the understanding that the chances of this case being moved off that August date are slim to none?
Absolutely.
And that, barring some true, just legal issue that I have to honor for fairness and justice to prevail, outside of that, we are going to make this case go. And everybody can agree with that?
Yes, sir.
Ms. Williams, you've talked with your client about this ahead of time. I know that. She is still in custody. I understand that today would have been a better day. Is your client also comfortable with that August date?
I don't know if comfortable is a good word, but I'd advise her where we are and what moving it to August would mean. And strategically, I think, and practically, she trusts me and my advice, and so I think we are in a position where we'll be okay with August.
Okay. All right. Based on what's been presented for me today, I'm going to We'll place this on, I believe it's August 3rd. We'll place this on August 3rd. And with the understanding that if I'm going to bypass 2 trial weeks in order to get there, I'm bypassing 2 days that I could set it on, right? But by doing that, I'm giving defense and state all the time that you could possibly need to have this case ready. And August 3rd needs to be our day. We need to come in August 3rd, ready to pick a jury. All right? Where everyone's on the same page.
Yes, sir.
Okay. Again, I do want to stress how grateful I am to defense and state on how well y'all attacked this case. The general public, I don't believe they fully grasp the difficulty of preparing a case like this. While we did set this at a very ambitious date, August still has Miss Patrick getting tried within a year of her indictment. In other words, we will not reach a year of her indictment in her case. Again, for a case like this, if you look across the state and the country, that is very fast, even in August, Ms. Patrick. And I believe your attorneys probably explained that to you to some degree. But it does need to be August. So August 3rd.
Thank you.
Thank you.
All right, so for those that are just coming in, we do have another update. We're showing hearings, right? So trial is scheduled, as you heard, August 3rd, and I have a couple more hearings. I have 2 more hearings to play, but we have another update. The first update from the media company was jury selection starts today. The judge issued a bizarre media order, which we've talked about, but in case you're coming in and you don't know, that it's going to be only video, so no audio. Doesn't make sense, right? Attorney has contacted the court. They're waiting to hear back. I thought that they wouldn't select a jury today regardless, but now the latest on that, the court doc, Sarah Grace was number 1 on the docket for jury selection. Now she's been pushed to 6. So there's case number 4 is Georgia versus Eric Allen Hall. Case number 5 is Atticus Fernando Johnson. And now case number 6 is Sarah Grace Patrick. So she was in the number 1 spot on the docket for today. Now she's been pushed to 6. So this trial definitely is being pushed out. I mean, not days or even weeks for sure, but certainly no jury selection today. I mean, I hope they get to it. I hope they at least start talking to prospective jurors. But initially, I didn't think they'd select a jury today. I thought it would be at least a day for them to go through the process. But now for sure, no way they're even going to. They may not even get to talk to, maybe they'll talk to the first group and that'll be it. And that'll be this afternoon probably. Unless these other cases go really fast. These other, cases in front of her, they could only be 10 or 15 minutes and they could get to her by noon. But in any event, jury selection was scheduled for today. She's still on the docket, but she's number 6 now. So that means there's five cases in front of her. So certainly no trial will be today. There's just no way she's going to start today. Maybe, hopefully tomorrow, and then we don't even know. While the media company is fighting to have audio and video, we still don't know that. So we're going to continue on with our presentation. And if we can get a stream out of this trial, fantastic. And if we don't, then obviously we'll bounce to something else. So anyway, we would love to have this streamed for you guys. I want to watch it. I'm very interested in it. I know our community is very interested in it. So fingers crossed we will actually get to see both. All right, so now here's a hearing which we did not cover. We haven't seen this hearing yet. This is from January 31st. So that other one was from January 5th, and now this one is from January 31st. So let's check this out.
State approached me in chambers with a stack of letters. I have read each of these, and I want to say I greatly appreciate y'all getting them to me ahead of time. I know some of these are from the, I think I have 2 separate grandfathers that wrote a letter, grandmother, several family friends that were in here, some that have been lifelong friends. There were also a couple letters from people that just met Miss Patrick after the incident. There was one that was very kind, even said, Judge, I don't envy you and the decision you have to make and the weight of that. So that person, I appreciate that as well. I say that just to let you know, I did read these. And I picked out one in particular that said that so that y'all know I did read these. And they do matter. No matter what the decision is that I make today, these letters do matter and they have been read and considered. All right, State, you ready as well?
State's ready.
All right, defense, it's your motion.
Thank you, Judge. We are here just for the record on a motion to reconsider bond. We had originally been denied bond back in August of last year, 2025. And since that time, Ms. Patrick has been in custody. I made the court aware at that bond hearing that she was at that time in solitary confinement and still remains in that posture in the Carroll County Jail. So I wanted that to be at the forefront of the court's mind. And with that, Your Honor, we will call witnesses in addition to those letters if the court will so allow.
My understanding is you have 2 witnesses?
That's correct, Your Honor.
All right, call your first witness.
Dennis Nolan, Sr.
Yes, sir. You'll come around and then remain standing while I swear you in. To remain standing, raise your right hand. You swear affirm the statements made before the court today, the truth, the whole truth, and nothing but the truth, so help you God. I do. You may be seated. If you would, just once you're seated, pull that microphone a little closer and speak loudly and clearly into the microphone. And we'll start off by just stating your name first.
My name is Dennis Nolan, Sr.
Dustin, you gonna be good?
Okay.
Thank you.
Good morning, Mr. Nolan. I believe the microphone just went off.
When you pulled it, it may have pulled this. You have to speak loudly and clearly for us, okay? My clerk just said that apparently the other day they had this issue with another court and IT had to come, so just speak up and speak loud for us, okay?
All right, Mr. Nolan, how are you related to Sarah Grace Patrick?
She's my granddaughter.
And are you her maternal or paternal grandfather?
Maternal.
Maternal?
Yes.
And so Kristin was your daughter?
Kristin was my daughter.
Okay. Now,
All right, so we do have an update that the trial has been pushed to next year. So, in fact, we will get to the hearing that talks about this, why it's been pushed, but it's been pushed to the next year. It's been pushed to next year. So today's trial start has actually been pushed to next year. So there's going to be, we'll continue on showing these hearings. This is from January 31st and then from July 13th. The July 13th one, they asked for a continuance and apparently they got it today. So the latest update is that trial has been pushed to next year. And as we find out more information, we'll let you guys know.
Mr. Nolan, have you received, I'll just get to the issue at hand. Do you believe that Sarah is a danger to you or anybody else in this community?
Not at all. No.
Okay. Do you believe that she is a threat to intimidate any witnesses that may be a part of this case?
No, absolutely.
Have you ever witnessed her threaten anybody or do any harm to somebody that you know of?
No, not at all.
Okay. Do you know if she has a driver's license?
She does not.
Does she have a learner's permit?
Not that I know of.
Okay. Does she have a passport?
No.
Okay. Are you aware of how she became arrested in this case?
Yes, pretty much.
Okay. Did she turn herself in, or did the police have to go get her?
She turned herself in.
Okay. And was that with you or with her father?
Her father.
And is her father, let me ask you this. Were you ever living, was Sarah ever living with you?
No.
Do you know of Sarah to have any access to any money that would allow her to leave this jurisdiction?
No, nothing at all.
If she is released on bond, would you be a part of the village to make sure she gets back here to court?
Oh, yes, absolutely.
Okay. And where is it that you live, Mr. Nolan?
I live in Rome, Georgia.
About how far away is that from here?
It's about an hour and 15 minutes.
Have you received any money from any publications or bloggers or anything like that in relation to this case?
No, nothing at all.
Do you know if Sarah has received any money from any of those sources?
No, not at all.
Do you know if Sarah has any money stored up in some savings account to be able to flee the jurisdiction?
No, nothing.
Now, how old is Sarah?
She's now 17.
Did you write a letter to the judge in reference to this case, or to the bond in this case?
Yes.
Okay. And the judge has indicated that he's read that, so I'm not going to have you read it today, but it is a part of what the judge has been turned over. Okay. Do you know if Sarah has ever been arrested before?
No.
No, she has not, or no, you don't know? Okay. Right, that's all I have at this moment.
And I have read your letter, I appreciate it.
Good morning, Mr. Nolan. How are you?
Good, thank you.
Good. Now, you and I have spoken before, is that right?
That's correct.
A number of times, 8 times, 6 times, something like that? Okay. Almost always in our office, is that fair to say?
Yes.
Okay, and you've been invited to our office multiple times. You do live in Rome, so you can't always come down, is that fair to say?
That's correct.
Okay, so our office has been open to you throughout this process.
Correct.
Okay.
That's correct.
I do want to talk to you a little bit about what you just spoke with opposing counsel on. You said you never lived with the defendant before. Would she be staying with you now in Rome?
No, I don't, no.
If the only way the judge granted bond was for her to stay with you in Rome, would you open your home to her in Rome?
Probably.
Probably, okay. Where would she be staying? Where would she be staying?
With her best friend, whose mother's Carroll. I don't know if she's here.
So the defendant would be staying with her own best friend?
Yes.
Okay, and who is that?
Carrie, I'm not sure of her last name.
Okay, Carrie.
Yeah.
Okay, now, does Carrie live in the state of Georgia?
No, she's just over the border in Alabama.
I believe we heard from her at the last bond hearing. So she would not be staying in state, is your understanding?
No, it's just, she lives right at the border.
Sure, understood.
It's what I feel the best for.
Okay, now, you were asked a question a minute ago about whether you had sold anything. You were at one point negotiating with media companies regarding the story. Is that fair to say?
That's correct. Yes.
Okay, what companies were you negotiating with?
Oh, it was probably 10 or 15 of them. don't have listed here.
Sure. Did you sign a contract with any of them?
Yes.
Okay. Which media company did you sign a contract with?
Lady Well.
Can you spell that for me?
It's LADYWELL.
Okay. Lady Well. Okay. How long is that contract for?
Well, it's for production that will be post-trial.
Okay. Okay. And what was the compensation in that contract?
I don't recall. I didn't receive anything for signing the contract.
Okay.
There's monies to be paid after the production is made, which would be after the trial, after the production.
So it's all on the back end. Okay. What's that amount?
Well, it depends.
Objection relevant?
Yeah.
Judge, this goes directly to the family's ability to enable her to leave the jurisdiction. This is something that was talked about at the last hearing, where the family had assets. The court determined she was a flagrant because of those assets. Those assets have now increased by, I'm going to guess, between, I'm not going to put a figure on it, I'll let Mr. Nolan put a figure on it, but if the assets of the family have increased and that was a concern for the court last time, it remains a concern for the court this time.
I believe, Your Honor, the testimony is that it may become an asset in the future, not that it's a current asset. And so it not being a current asset, I believe, blocks the relevance of the importance of the dollar amount at this point.
Judge, there's a significant difference between them selling the rights for $1,000 and some of them selling the rights for $1 million.
Let me ask attorneys to approach. Is this the microphone for your camera?
Yes, sir.
Can you cut that for just a minute?
Yes, sir.
All right, so while the attorneys are at a sidebar, we do have breaking news. Breaking news. All right, so the trial has been continued. There is going to be no trial even this year. They've pushed it to next year. And the reason is there's been new evidence, and that's from the hearing that was from July 13th, where they asked for continuance and they were not granted it. But then I guess apparently today they were granted a continuance. So the trial will not happen this year. It has been pushed to next year. I don't know a date yet. If they even have posted a date, I don't know. All I know is right now that they've pushed it to next year. So if you're just joining us and you're looking for any information, we knew jury selection was supposed to start today. I didn't think they'd select a jury. Then she got pushed from number 1 on the docket down to number 6. And then now it's just been pushed, which would have pushed, jury selection probably till tomorrow. But then we also have heard that the trial, from people in the courtroom, trial has been pushed to next year.
In addition to the reason that I stated prior on the record, I think this goes directly to the veracity of the statements of this witness, Judge. I think we heard statements just moments ago from him that directly contradict what we're talking about here today. I think this is a relevant area to go into at this point.
I'm going to allow for questions at this time. That was just so the bench conference. That was my concern. I was making sure that that's where we should be potentially this argument. So I'm going to allow for questions.
Okay. So I'm going to go back. What is that dollar amount?
What is the total amount?
Correct.
I'll be honest with you, I don't recall because it happened months ago. But I believe it was somewhere around $100,000.
And is that $100,000 that will go to you?
No.
Who will that go to?
Go to whoever the production company feels contributed to the production.
Okay. So that money will be parsed out depending on who participates in whatever.
Right. If it's all post-trial.
Sure. And who are the parties to that contract? There's Ladywell who's on one side. Right. Who is on your side?
Myself, Luann, DJ, and I believe that's it.
And by Luann, you mean Luann Bruce, the maternal grandmother.
Yeah.
And you mean DJ, the biological father of the defendant. Did they pay any upfront money to you? No. No penny at this point. Not a cent has come your way.
No.
It is all on the back end. Correct. And I want to be clear. Get your testimony here today that none of that money will be going to Sarah Grace. It will be going to Luann and DJ. Correct. Is that your testimony today?
That's what I understand, yes. That's my understanding of what's in the covenant.
Okay. It will not go to Sarah Grace Patrick, correct? Okay. Understood. Nothing else at this point, Judge.
Anything else?
No, Your Honor, not for this.
You can step down. Thank you. Call your next witness.
Luann Bruce.
You can come this way. No matter. If you remain standing, raise your right hand. You swear affirming statements made before the court today, the truth, the whole truth, and nothing but the truth, so help you God. Will you see? I apologize for my mic being out. You'll speak loudly and clearly for me, just to help everyone out. I greatly appreciate it. Just imagine that you're talking through a door, okay? If you'll state your name for the record.
Luann Bruce. All right, Miss Bruce, how do you know Miss Patrick? She's my granddaughter. She's your granddaughter. Is she your maternal or paternal granddaughter? Maternal. Maternal. So you are Kristen's mother. Yes, ma'am. Okay. And has Sarah ever lived with you?
I mean, she stayed with me off and on,
but visitation as a grandmother, that kind of thing. Okay. Let's address this money issue. Have you received any money from any production company, bloggers, whatever, in relation to this case?
Not today.
Not today. Okay. Has there been any promise of money to you in the future for the rights to this and that type of thing?
After the trial, yes.
Okay. After the trial. But at this moment, you have not received any money as it relates to this case. Okay. Do you know if Sarah has received any money as it relates to this case?
Not that I know of.
Okay. Have you given her any money from a production company that you received?
Oh, no.
Okay. Do you know if Sarah has a driver's license?
No, she doesn't.
Does she have a learner's permit?
No.
Do you know if she's learned how to drive a car?
I don't think so. They didn't have one that she could drive.
Okay. Does she have a passport?
No.
Are you aware if she turned herself in or was she arrested?
She was forced to turn herself in.
Okay. And when she turned herself in, do you know where she came from?
I think she was at our grandparents.
Okay. And that would have been the same house that's in Alabama? Okay. And where do you live, Luann? Like what city?
I live in there now.
Do you have, at this point, custody of... Okay. And that is Sarah's little sister? Okay. Are you afraid for the safety as it relates to Sarah?
Not in the news.
Okay. Is there any, has Sarah ever made any threats to you or to at any point in time, but especially in relation to this case?
No.
Okay. Has she tried to talk to her or change her testimony or anything like that that you're aware of?
I talk to Sarah every day when she's here. They're just loving sisters talking to each other.
Have you any reason to believe that she would flee the jurisdiction and not come back to court?
Not at all.
Okay. Would you be a part of the community and village that would be responsible for making sure she shows up for court dates in the future?
You bet.
Okay. Are you aware if she's ever been arrested before?
No, she hasn't.
Okay. And you wrote a letter in relation to this case and this bond this morning? Okay.
I didn't think I was going to be able to be here.
Okay, right. You had another work obligation.
I couldn't get out of it.
The ICE changed that. I think it changed a lot of things for a lot of people. But that letter is a part of what the judge has reviewed, and so I wanted you to know that that is a part of it. Now, you are one of the, I guess, victims in this case, right? Would you consider yourself one of the?
I'm very much a victim.
Okay. And I'm sorry?
My whole family.
Your whole family. And you are in support of Sarah
Very much so.
and her being out on bond.
100%.
Don't think I have any other questions.
Thank you. State.
Thank you, Judge. Good morning, Ms. Bruce. How are you?
I'm good. How are you?
I'm doing well. Again, same kind of starting questions. You and I have had conversations in the past, is that right? Okay. I do want to ask you just a little bit about those media rights that we've been talking about. How familiar are you with those media rights?
I mean, vaguely familiar. I mean, I've talked to them. And, it's all based on what will happen after the trial.
Sure.
And who they're going to, make go through all the going in pictures and stories and all that kind of stuff.
Okay. And the three people who are involved in that are you, Dennis, and DJ. Is that correct?
Correct.
So the $100,000 or so that we've been talking about, that will get sort of divvied up between that group. Is that right? It won't go to Sarah Grace. It won't go to her sister Jaylee. It won't go to anybody else. That's money that's going to go directly into your pocket if you were participating. Okay. Now you don't live near here either. You live up north of here, Marietta, right? And you said Sarah Grace has never stayed with you. Is that right? Long term.
She's stayed with me.
Okay. She will not be staying with you. She'll be staying in Alabama if she's granted a bond. Okay.
However, I have a 6-year-old that takes up a lot of my space and her toys.
Correct. If the judge were to say that the only way she can get a bond would be to come home with you, would you be able to house her?
I'd make it happen.
So when your husband said probably, he was really waiting for you to say absolutely.
Now they're no longer together, Judge. They are.
Oh,
Excellent.
So I'm going to
And have you ever been to the house in Alabama where the defendant will be staying?
No.
How long have you known this person, Carrie, that she'll be staying?
I've just known of her. I met her here last time. I've not really known her.
Okay, so you just met her here earlier this month?
Well, I guess I've met her.
One of the prior hearings?
There's something like that.
At the prior bond hearing back in August, probably?
Yeah.
That's on her? So you don't know her very well either?
But I will.
I'm sure you will. I have no other questions for you. Thank you so much.
Anything else?
Briefly, Your Honor. Ms. Bruce, is it your intention to get Sarah out on bond so that you can, help the production company get footage for their documentary and all of that stuff?
Absolutely not. Okay. I'm here for my granddaughter to get free. I think she's unjustly being charged.
Okay. Thank you.
Anything else to say?
Nothing else, Judge.
All right, thank you. You may step down. Yes, ma'am. We only have argument.
Yes, Judge. I do want to quickly make that same packet. It is a photocopy of the exact letters that I've given to the court as part of the record as defense's bond exhibit 2.
Any objection?
None to the state, Judge.
All right, they'll be admitted.
Thank you, Your Honor.
We can get at the end.
Okay.
I'm ready for argument.
Okay. Your Honor, we believe that Ms. Patrick is in fact a good candidate for bond. I think that on the last bond hearing, the court heard from Ms. Bowling, who is the sister of James Brock, and her statements were of impact. She came up, she was emotional and teary-eyed, but the fact of the matter is that she is, as I told the court, only one side and one person of this victim family. I use the air quotes because, again, it seems as if to counsel that Ms. Bruce and Mr. Nolan are not being treated with the same gravity. Their words and their support for Sarah is not being treated with the same gravity as the other side of this, when in fact they are of closer relation as mother and father to the deceased than Ms. Bowling would be to her brother. And them being in support of Sarah, I think, should hold with this court more gravity in ways because of the close relation of them having birthed the deceased. Not to discount the emotion or feeling that Ms. Bowling may have for her brother, but that is a closer relation. The four factors that the court has to consider is that, is she a threat to the community, a threat to witnesses, risk to flee, risk to reoffend? The state wants to say that, oh, there's this influx of money and so she's gonna run. That, Your Honor, is at fault in the argument because none of that money belongs to Sarah. None of that money, she again is 17 years old. She's not an adult. She doesn't have a bank account. She doesn't have a driver's license, a passport, and they don't even think she knows how to drive. Not that Miss Bruce is aware of that she was even taught to drive. They didn't have a car for her to learn how to drive, was the testimony. And so her being a risk to flee, I think, is totally unfounded in that she turned herself in voluntarily from Alabama. I think the state is going to argue to the court that she won't even be in Georgia. The court heard from Ms. Jensen on last bond hearing, so I didn't bring her back up, that she does stay right across the state line, and her house is where she came from voluntarily to turn herself in and be at the mercy of the sheriff's office and this court. And so I don't think that going back to Alabama would be a problem at all. It is a part of Ms. Jensen's letter that is a part of what has been turned over to the court, that she would be welcome there. We as a group, I've spoken with the family and with Ms. Patrick about where would be the best option for her to stay. I will say to the court that I have a list of some odd 15 people where she could reasonably stay. We have, as a group, considered all of those places and what would be the best course of action for making sure she gets to court, having a stable environment, being in a place where she could be away from the media frenzy that I think will surround her here in the immediate area. And so we just made that decision that Ms. Jensen's home there in Alabama, where she's already comfortable and would have the ability to stay off of social media, be somewhere where she wouldn't have the need for a phone and that type of thing, which I would ask the court to make that a part of the conditions of her bond, that she not have access to social media and a cell phone of her own. And that home just landed as the place that I think had all of those things encompassing, and a place where she would be comfortable. But that's not the only place that she could go. Your Honor could order that she stay here in the Carrollton area or in the surrounding area, and she has those places available as well. Several people have said that they would make sure that she has a place to stay and that she is housed. So her going to Alabama, I don't think should have that much weight from the court as a cause for concern. As it relates to a threat to the community, the people who are victims have said she is not a threat to them and a threat to witnesses. She is not a threat to them. She is not a threat to never has been and never will be. And so the people who are closest to her, who talk to her on multiple occasions throughout her life, not just somebody who started talking to her after the incident happened, but they have said she is not a threat to the community, she is not a threat to witnesses. She is not at all a risk to reoffend. When we look at the risk to reoffend, I think that generally the court looks at a person's criminal history, because we know past behavior is indicative of future behavior. She's never been arrested. That was presented at the last bond hearing. She still has no criminal history, hadn't had any incidents in the jail or anything of that sort. As a matter of fact, I think she is thought of and spoken very highly of by many of the guards there at the jail. Your Honor, we have presented to you 21 character letters. 21 people who are willing to vouch for that young lady sitting in that chair. 21 people, not just one person who is filled with emotion and feels like, oh, you know, that they have an emotional reaction to what has happened. 21 people. In addition to those 21 letters that is a part now of the record that Your Honor has written, my right side, the court's left side, entire courtroom is here to support Ms. Patrick. People who are going to run generally don't have that type of support. People who are going to abscond from justice generally don't have that type of support. People who intend to not come back and not do the things that they're supposed to do not have this type of support, Your Honor. I think that that is something that the court should look at in a major way as to the risk to flee. Is that when you have connections and ties, not only to the immediate community, but just to a community in the aggregate, that is what keeps people accountable. And essentially, bond is for there not to be any new crimes, which she doesn't have any indication that there will be any new crimes because she doesn't have any criminal history, and we maintain her innocence that she has not done this that she is accused of, but also that she just has the vast support of the community around her, and that they have said they will hold her accountable. That is a part of the letters as well as the testimony today. Again, as it relates to the money, Your Honor, if there is this vast influx of money, Your Honor, I'm sure, would not grant a recognizance bond. There would be a monetary amount to it. So any money that there is that I think that the family has come into the way that the state wants to portray it would be going to that bond, I can assure you. And in addition to that, she is indigent. And if there is any other monies would be going to the hiring of an attorney, I would assume, if they could afford that based on this sudden influx of money, which the testimony has been, is that no money has been given to Mr. Nolan or Ms. Bruce, and that everything is post production. As it pertains to the veracity of their statements, Ms. Bruce was clear that they're not trying to get her out to, have her do interviews or anything like that. As a matter of fact, Your Honor could order that she not have any of those contacts or any of those interviews until after the trial. There is case law. I was not able to look it up because I was trying to pay attention and question, but I am certain that there is case law that, as a matter of fact, the defendant cannot profit off of books or publishing rights and those types of things as it relates to their case. And so I'm not sure if Your Honor is aware of that, and I can find the site as I continue to look and present it to the court if need be. But Your Honor, she has a place to stay. If Your Honor would require that she stay in Georgia or stay around the area, she has those places as well. We could provide addresses to the court. And so we're asking that Your Honor would grant a bond in this case. She is in solitary confinement as a 17-year-old. the courts have acknowledged that solitary confinement on juveniles is, even though she is being charged as an adult, she was at the time of the incident and is now still a juvenile, that it has vast implications on the mental health of persons, not just juveniles, but persons in general that are in solitary confinement. So I'd like the court to consider that as well. We filed this bond motion, Your Honor, because of the pushing back of the date, which was no fault of Ms. Patrick's and no fault to the court. I think that it was what had to happen based on the circumstances. But the additional 8 months or so where we're going to be waiting, I think, is a factor that I think the court should consider in weighing whether or not the court grants bond today. But we would ask that Your Honor would grant a monetary bond with conditions. I am specifically asking that Your Honor would grant the condition that she not be allowed the use of a personal cell phone, that she not be allowed the use of social media. Your Honor has tools in his toolbox to say to keep her confined to a particular address. She can be on ankle monitoring, house arrest, with not the ability to go out and socialize or do any of those things. We now have the technology of GPS monitoring, so it's not just are you at home, they can tell exactly where you are. So if there is any question about whether she'll be out, being a threat to witnesses or the community at all, she could be closely monitored and will be closely monitored by her family. So Your Honor, we're asking that you would grant a bond in this case with the conditions that she not have any contact, of course, with witnesses, that she not have any contact even with, the Mr. Brock's family, if that is a concern, and also that she be on house arrest, ankle monitoring, GPS monitoring, so that the court will be aware of where she is, and I have no doubts that she will show up for her court dates. She is eager to assert her innocence. And so, Your Honor, that is the ask of the defense at this time.
I want to say, Ms. Mitchell, if you'd like to come grab a seat, you can. I also did observe you helped that young man in the back of the courtroom. Did you get him where he needed to be?
Yes, Your Honor, I did.
All right,
Thank you.
so,
Judge, I'm just waiting to grab an indictment to sign someone up perfectly.
Okay. Madam Clerk, can you handle what she needs? She can go ahead and be productive. But I did look over that. I appreciate you helping him out. You could tell he was stressing. He didn't know where to be. Thank you. All right, Mr. Parrish, you ready?
I am, Judge.
Come on up.
Judge, the state does oppose bond in this case. They've done enough bonds with me to know I follow a particular protocol when I go through my bonds. I always start with the case history. We're talking about an incident date of February 20th of 2025. That is less than 12 months ago. An arrest date on this case was July 8th of 2025. This case went before the grand jury August 19th of 2025. We had a bond hearing on August 19th of 2025 as well, which I'm going to talk about in a minute. The trial court date on this case is set for August 3rd of this year, which is less than 1 calendar year from indictment. That is incredibly fast. Opposing counsel did mention the additional time based on the continuance that for all intents and purposes had to be granted. That is not a consideration for the court. The court's structure in regards to this is pretty straightforward. There is no material change in the circumstances of the defendant. That's where we are. I'm going to read from that bond order on August 19th of 2025. After hearing evidence presented regarding the defendant's motion for bond, this court finds the defendant is a risk to flee the jurisdiction, not appear for future court appearances. The defendant is a risk to influence witnesses. The defendant is a threat to the community and family members as testified to at defendant's hearing regarding bond. Through all of the testimony and argument we have heard today, there has been nothing to dispute that fact. If anything, I think it could be argued that the flight risk is actually more significant now than it was before. The family in this case does oppose bond, Judge, and one other thing that I do want to address is that was at the beginning of opposing counsel's argument. Our relationship with both sides is as much as we can make it. Miss Bruce, Mr. Nolan, and and DJ, the biological father of the defendant, they have been invited to our office constantly. Anytime we have spoken to the Brock side, we have reached out to the other side as well. They choose not to come. I sat down on that August 19th, 2025. We sat up in our brand new grand jury room up on the 5th floor, and I sat and answered their questions for at least a couple hours. I think it was about 2 hours that we were up there. They have been asked to come in every single time. I am inviting them to come into our office to talk to me today, tomorrow, any day, anytime. I cannot make this more clear. Anytime they want to come in and talk about the case, I am available to them. If they want to, we can set up a conference call on a weekend. If they need me to drive up to Marietta or up to Rome, I will drive up to Marietta or I will drive up to Rome. I drove up to Marietta a couple weeks ago with my investigator. Ms. Bruce was actually not there. So we have tried our very best to have a good relationship with them. They have turned their back because they do not believe that we are prosecuting the right person for this case. That was something I told them from the very beginning. I'm going to be as open and inviting as I can be, but we are not going to agree on that fact. They choose not to come in, Judge. I have conversations on the phone with Mr. Nolan and with Ms. Bruce because they live far away and it was difficult for them to come in. Any person in that family who wants to come in and talk to us can do so. At that meeting on August 19th, I told them to bring as many people as they want to. Friends, family, whoever they like. I invited them to record the interaction if they would like to. I have no problem talking to them. The state is not scared of talking to the family on either side. We invite them. Going back to the Brock side of the family, Judge, I do have a statement from them. They oppose bond as well for the same reasons that they opposed bond in the first time. I would like to read this statement from them if I could. The seriousness of the charges before this court cannot be overstated. The accused is being held and charged with the malice murder of 2 people. These were intentional violent acts that were permanently destroying our family. Granting bond in a case of this magnitude would undermine the gravity of these crimes and the devastating harm that she has already inflicted. Then they move to addressing the Ayala factors. We remain deeply concerned about flight risk. The defendant is facing the possibility of life-altering consequences if convicted. Given the severity of the charges, the incentive to flee is substantial. The immediate family has the resources which would enable her to flee. Her family maintains that she is innocent, and given her manipulative behavior, it is possible for her to flee. Once released, there would be no meaningful way to ensure the defendant remains within the jurisdiction or appears for future court proceedings, since family and close friends have homes outside of the state of Georgia. We are also gravely concerned about witness intimidation. This case relies on witnesses who must be able to cooperate freely and safely with law enforcement and with the court. Releasing the defendant creates a real and reasonable fear that witnesses could be intimidated, influenced, or discouraged from coming forward. Even indirect contact or perceived threats would be irreparably damaging to the case. Finally, and most urgently, we fear for our own safety. The loss that our family has suffered has traumatized us and left us vulnerable. The thought of the person accused of killing them being released into the community causes us constant anxiety and fear. Bond would not only endanger witnesses, it would also place our family under continued emotional distress and fear for our physical safety. The accused is being charged with 2 malice murder counts. These are horrific and violent crimes in which she is being accused. The defendant's second bond request This is the defendant's second bond request, and nothing has changed that would justify reconsideration. The risks remain the same, if not greater, as the case moves forward and the consequences become more real. Our family would not be able to sleep in peace knowing that she is not in protective custody. Judge, it's the state's position that on August 19th of 2025, she was a poor candidate for bond, and that as I stand here before you today, she remains a poor candidate for bond, and bond should be denied as such.
Who made the statement?
That was crafted by Kim Bowling on behalf of the other family, the Brock family.
Who was that for? Who made the statement?
Kim Bowling.
No, that's the sister.
It is.
At the past hearing, we also had a brother testify. Is that right?
We did, Judge. We had sons. We had sons and her, and then a friend of the family as well, if I recall correctly. It's going back a little bit.
I believe it was her brother, stepbrother. Is that correct?
I think so, Judge.
Is that right?
That's correct, Your Honor.
And he was not in favor at that time as well, correct?
Correct, Judge. There's significant numbers on this side as well.
And they lived together for a period of time, correct? The brother? That was my recollection, that he was in the house for a period of time. Am I correct?
Not in recent memory, Judge. Not in recent history, is my understanding.
Anything else from the state?
Nothing else from the state, Judge.
Anything else, Ms. Williams?
No, Your Honor.
Look at these letters. I believe it was actually Miss Carrie Jensen's letter that I referenced before I got started. She said, "I truly understand the difficult position this bond hearing places before you and deeply respect the weight of your decision." And I didn't realize I was actually going to be referencing hers. But that's who Miss Jensen's the one who wrote that. So in preparing for this hearing today, I was prepared to listen for and hear anything that showed that there was a material change. As of right now, I don't see that there has been a material change. The only real change that has happened, one, is the court date change, and then two, I don't believe I had the information in front of me that family members had signed contracts with different media companies at the prior hearing. So that's new material. When I look at this, when I asked the state and defense to come up and the witnesses were testifying and the defense objected to the line of questioning the state had, my concern was I wanted someone to ask or bring up the question of the veracity of these statements, because while I know, and I hope the family hears this, I'm not doubting your love for your granddaughter or your daughter. Is Mr. DJ here? That's not in question. And I think I said this last week. So whatever ruling I make today, do not think that it is me determining your love and care for your daughter, right, or your granddaughter. With that said, I do have to consider some of the things that have changed, and with these type of contracts, if she were to be released, y'all could benefit from your Ms. Williams actually used the term media frenzy. The more that's brought about, potentially the higher, the more you as individuals would receive potentially. So while that's not an factor that I have to evaluate, that is some of the change that in consideration of where she's going, who she'll be with, and they play into the factors of what could happen. But again, that does not play into whether or not you care or love your granddaughter or your daughter. Going to the court dates, I don't believe that really goes into the material change argument, but it is a change in dates. And I want to lay this out. Ms. Patrick, I tried to take some time with you last time going through the arraignment process and going through the grand jury. So I'm going to lay this out for you today, okay? A typical criminal trial that most people don't realize, for that to be fast, for a criminal trial, especially one like this, a murder trial, or child molestation, or rape trial, these heavy crimes, right? Most people in the judicial world would say that a year and a half is a really fast track for that case to be heard. And I'm sure your attorney's probably gone over this with us. You're even shaking your head yes, like you understand that to be the case, right? So right now, when your case first came up, the first court date that I gave you, I was trying to push because I know your age. Right? And I want everybody to understand, by me giving those first dates, do not drag your feet. But in all candor, if you remember, if you go back to that hearing when I set that date, I kind of had a little caveat saying, I understand this may be pushing. Right? And what happened was, is when we came up, the defense, you announced ready, but in actuality, you didn't even have your full report. And to do that, you would have needed that. If we'd have started that day, you were thinking you might have the report by Friday, but you weren't sure. But I think you did what you had to do in the moment. Say you were ready, but you were announced ready without the full report that you truly need. State needs that report. They need that full report to do their job and have their expert. So as both of you stated that day, and I believe the state even addressed here today, the continuance had to be given. The continuance had to be granted for fairness to take place, right? Fairness for you and your attorney to actually get the full report, and fairness for the state to be able to prepare for this case. Now, in doing that, I had a couple of different dates available. The state and defense both came to me and said, Judge, we know that you don't want to move this case again. We want to put it on your August date. That was the date that was agreed on by the defense and the state. If I look at the dates, right now we just acknowledged, and you were shaking your head yes, as if you understood, that a year and a half is really fast for these type cases. That's typically as quick as one will get, right? If I look at my dates now for your August date, you hit right at almost exactly a year and a half. So even with that August date, your case is still moving at an incredibly fast pace. You realize that? Now, with that being said, state and defense also know I do not want to continue this case again. Right? And we're going to do everything that I can. I'm going to do everything that I can to prevent this case from being moved. Right? It's my understanding there may be some changes that take place. If those changes do take place, I do anticipate signing an order to specially set this. If there are conflicts, I commit to both state and defense. I don't mind calling other judges that may have conflicts and ask them if they don't mind if we jump ahead in line so that I can have attorneys report to me so that we can make this happen. And I hope that we can do that. But when I look at this again, I think the state's correct. I have to evaluate it for material change, and I don't see much of the material change. The risks that were there at your first bond hearing still exist. I do have to say I can see both sides, but I do see from the state saying that things may be even intensified with these contracts, because that brings a whole level again of motivation. If you're like, what's going to motivate you or that side to do things? Because the more that's there, the more they have, the more potentially they get. That's a risk too. So based on that, and based on evidence that was given to me at the prior hearing, I believe any time that I make a ruling that takes into consideration statements that were made at prior rulings, I have to place that on the record. So I am placing on the record that part of this ruling is based upon the testimony that was given to me at the prior bond hearing. Okay, the statements that I heard then. And I'm not giving more weight to one side or the other. That's just not the case. What I am doing is properly weighing this to the best of my ability against the law, right? And that's what I have to do with these factors, right? Based on doing that, I am going to stand with the original order that I gave. If bond will continue to be denied, I do not find a significant material change in circumstances or facts that would allow or require me to make a change in that prior ruling. So the prior ruling will still stand. Your case is set for our August date. Attorneys, we will continue our meetings as we've done prior to this. I anticipate us still having our monthly conference calls to make sure that we can stay on pace, stay on track. If there's a change, please let me know if there's a change. And whenever that change is made, I will continue to bring that person in to continue with these monthly conference calls so we can keep this case on track. All right. I do want to say again, Ms. Williams, you and your staff and state, y'all have done a fantastic job keeping me informed of this case and making the report. I greatly appreciate that. Y'all have both done a great job thus far, and I anticipate y'all doing the same moving forward. That'll be the rule in the court.
Now, do you want to admit your copies, or I have it?
I have written on mine because they were my notes, so we'll take this.
All right, so that was another bond hearing that she was denied. She had one last August, and then she had one in January. Denied both times. So, in case you're joining us new or just joining us, I should say, today was supposed to be jury selection. It has been pushed to next year, and I think the reason why I should say is from this hearing that just happened on July 13th. So we're going to take a look at this because we have not seen this yet. Actually, we didn't see that other bond hearing either, but this happened just a few weeks ago, and she has new defense counsel. And I think this is the reason why, well, let's watch it. I don't want to give any spoilers, but I think this is the reason why it was pushed. So let's check this out.
And for the record, my name is Sean Hoover. I have recently joined, or I am the attorney for Ms. Patrick moving forward. Latoya Williams was the attorney. She no longer works with the Public Defender's Office, so I will be moving forward here on.
Now, I know that you paused and said recently you opened this case in February.
February, that's correct. For me, it's recent. I apologize. There's been a number of trials since been in now. So I've been on the case since February, Your Honor, and we're asking for a continuance today regarding Ms. Patrick's case. I know the court has already read the case law involved. Just to put a couple of highlights on the record. For starters, Your Honor, once I took over the case, I put an entirely new team on Ms. Patrick's case. With that said, I got the case. There was a lot of discovery involved. Started to go through the discovery while I was trying other cases. Once I realized there were certain issues that hadn't been addressed when Ms. Williams represented Ms. Patrick, I started to create a team or bring a team in that could address those particular issues. At the beginning, I thought it was just a chain of custody issue, and it turned into a lot more than that. To give you an idea or a little more of an understanding, I brought in Mary Dayton, who is an attorney with the Public Defender Office. I worked with her when I was with the Capitol Office. She has done a lot with juvenile clients, especially juvenile clients dealing with capital cases and dealing with forensics. What I thought was just a chain of custody issue turned out to be a much larger issue dealing with GBI, the Sheriff's Office, Police Department, and just evidence in general. With that said, we brought in also a mitigation investigator, Olivia, who's at the table with us as well, who also deals with capital cases, also deals with juvenile cases, but also deals with the mitigation aspect of it. Once Ms. Dayton and Olivia came in, we found out that based off of current case law, not only with the United States, but also in Georgia, certain issues weren't addressed when Ms. Williams had the case and Ms. Williams announced ready. Mainly because of the age of Ms. Patrick when the shootings actually occurred. Because Ms. Patrick was a juvenile at the time, case law is a little different when it comes to, for one example, sentencing in regards to how and when a juvenile can be sentenced to life without possibility of parole, death penalty, or life with possibility of parole. Because of those issues, I believe it was about 2 weeks ago, I believe Olivia just said that we got the defects information around June 30th, which literally wasn't that long ago. Yes, Ms. Williams had an expert that, to be nice, did some work on the case, but the expert didn't have Ms. Patrick's, and the expert I'm talking about, Dr. Schaefer, didn't have Ms. Patrick's defects records when he did his evaluation, when he spoke to Ms. Patrick and family members, when he came to his ultimate conclusion. Now that we have the defects records, that has opened up, for lack of a better term, a whole other can of worms in regards to not only sentencing because of Ms. Patrick's age, but also our theory moving forward, especially crossing certain officers and certain witnesses based off of the evidence that we did receive from the state. So with that said, we're asking for a continuance for multiple reasons. The first one will be because now that we actually have a team in place that can actually address the issues facing Ms. Patrick because of her age at the time of the shooting and because of all of the background history that Ms. Williams, she just didn't know about because she didn't have it. Literally, we sent you the order and you got the information as quickly as possible. But we're talking about over 10 years worth of information that now we have to go through not only for sentencing, but to combat certain things that I believe witnesses and especially officers are going to say on the stand in regards to their investigation. So we're asking for a continuance for that reason because we just need more time to go through all of that. Again, the case law, like I know the court's aware of the case law. The case law, not specifically, the case law points towards it's a sentencing issue, which it is, and we need more time for that. However, without going into more detail, there were certain statements made and certain reports that were written from the lead investigator and other officers, which tells me now that those defects records, the mitigation aspect of this case that we thought was something that we had to, that wasn't as important during the trial, well, now it is. Because based off of what we've read and based off of what we received, it will be an issue in this case, especially with the lead investigator. So the first point we're asking for a continuance is because we now have the team put in place to address the issues specifically based on the mitigation aspect of this case, which was not addressed before. Dr. Schaefer had an evaluation that the state has and the court has that he did not have the information that we have, and based off of that information, more needs to be done so that I can adequately protect Ms. Patrick's interests moving forward. Furthermore, we're asking for a continuance, Your Honor, based off of evidence that we believe is still outstanding. And when I say that, again, when Ms. Williams had the case, the state of Ms. Williams announced ready for trial. And I understand based off of the information that the parties had at that time, they believed they were ready. However, once I took over the case again, I thought this was just a chain of custody issue, and it turned into something a lot bigger. And to give the court an idea without going into too much detail about our theory, since I've taken over the case, I've actually been able to delve or dive deep into it. There are issues with what officers did in this case. There are issues with the Georgia Bureau of Investigations in this case, and we have started to get more information, more evidence from the Georgia Bureau of Investigations and from law enforcement. With that said, the state and I met on Friday in person to go over the physical evidence in the case, and we talked about that as well. And the state is helping us get more information. And to be clear, this is not an issue that like the DA was hiding information. This was more of I saw an issue that I believe Ms. Williams just didn't see, and it snowballed into something a lot bigger than just a chain of custody issue. So now we are still trying to get information from Georgia Bureau of Investigations to fully understand the forensics in this case, to fully understand the chain of custody issue in this case, to fully understand the procedures in this case. And we are literally still requesting information from GBI that's still coming in. And now we've actually asked the DA to help us out on that because this is information they need as well. So this isn't something that's like, well, aha, we knew about this earlier. This literally, again, started out as a chain of custody issue, and it has snowballed into something bigger to where we're going, and this deals with possible 702 Daubert issues moving forward. We're literally dealing with forensic evidence. We're literally dealing with chain of custody issues, proper procedure issues, not only through local law enforcement, but through the Georgia Bureau of Investigation. So we're asking for a continuance on that as well because there's still information coming in. And finally, Your Honor, and again, this is not me saying the state withheld anything because I honestly believe the state didn't know about this as well, But on Friday, when I met with the state to go over the physical evidence, they sent a supplemental report from an officer with local law enforcement. The issue is this officer is in other reports. This officer is on the witness list. But from the information we received, the information Ms. Williams had, this officer literally didn't really do anything in the reports. He was just there. Now we find out that this officer did not write a report. However, he went to the DA's office literally last week and said, you know what? Well, and I'm sure they can correct me if I'm wrong. My understanding, this officer had a hunch that the gun that was possibly used for the shooting was pawned by a certain person we never knew the name of from the discovery sent over by the DA. And that officer's hunch turned into, it went to another person that had the gun, and the officer tested the gun and then gave it back to the other person. We had no idea these two people existed. We had no idea this test existed. We had no idea there was a possible another gun. We had no idea there was a possible hunch. We have no idea how the officer came to that conclusion. And again, Ms. Williams of the state announced ready for trial for January. The state didn't even know about this. We are now in a position to where I honestly don't know, was this one rogue officer that just did literally whatever he wanted to and never reported to anyone else? Or is there more involved in this? I need to now follow up on the hunches. I need to now follow up on how he even got to this conclusion. I need to now follow up on the two people. Well, it is more than two people at this point that I didn't know about until Friday, literally Friday afternoon, that I need to now follow up on them. I need to go to the pawn shop to see what happened there. I mean, there's so much more information that we have uncovered since I've taken over the case and I brought my team on, that we can't fully be prepared to go forward with defending Ms. Patrick. As of right now, and again, this is not the DA's office that held any of this information. This was now I see there's a problem. I thought it was a small problem. It has snowballed into a huge problem, and as of Friday, now we know that there are officers that really didn't do anything or didn't provide anything in evidence that was presented to or turned over to Ms. Williams and then turned over to me, that now they're coming out the woodworks that there are possible other guns, possible other suspects, possible other contacts, possible other connections that no one knew about up until now. And again, the case law, the court has already read the case law, so I'm not going to delve into that, but we are in the position now. I understand this trial was set, or this case was set to go to trial. And I understand that Ms. Patrick has been in jail this entire time. She and I have had this difficult conversation, but I am in the position, due to her age, due to the circumstances surrounding the case, and due to the mitigation aspect, the new information aspect, the possible other weapons, other people. I mean, there's so much that has been uncovered within the last few months that we have delved into this case that we are asking for more time so we can be prepared. And not only for sentencing, but for the case in chief itself. The mitigation aspect of what we are looking into not only goes to sentencing, again, it goes to actual issues with investigations that these officers conducted, especially the leading investigator in this case. So the mitigation issue deals with her age, sentencing, and the case in chief, but now we know GBI evidence, that there's still more coming in, still more information coming in, forensic evidence, there's still more coming in. We will be having 702 Daubert hearings. We have to, on specific information, what will be admitted, what won't be admitted, who will be an expert. There's a chain of custody issue, and again, now there's new evidence that there's some rogue cop that now literally didn't write a report at the beginning, but apparently a couple years later, a couple weeks before trial, he remembered, now I need to write a report, and there's a new gun we need to talk about, there's new, again, forensic evidence we need to talk about, there's new contact information we need to talk about, and this is not from the state, this is information that we uncovered because I saw there was a problem, and the problem turned out to be a lot larger than what it was. With all of that said, Your Honor, due to the nature of the crime, due to the fact that Ms. Patrick is potentially looking at, 2 life sentences without possibility of parole. As a defense attorney, I need more time to uncover or to just delve deeper into all of this new information that we've uncovered before I can properly say that I can represent her zealously and cover all my bases. This is an issue that I don't want to come back 20, 30 years from now and have to relitigate all of this because another officer popped up with new information that we didn't know about before. Like, this is not I'm grasping at straws. There's an actual issue here that the state and I need to uncover before we can properly move forward with this case. So for those reasons, Your Honor, unless the court has any questions, we are asking for a continuance so that my team that we put together that is suitable to handle all this information can actually do just that. We just need more time because there hasn't been enough time yet.
Thank you.
Thank you.
State, do you have a response?
I do, Judge.
State your approach and give your response.
Thank you. I do want to just touch on a couple of things. First, in basically the order that defense counsel went through them, he said that there is a new team that they put together specifically for the mitigation or issue, specifically regarding the defects documentation. We'll break that down a little bit. First, they put their new team together and they want to change their expert, but they're only doing this in June. February, they didn't ask for this. March, they didn't ask for this. April, they didn't ask for this. May, they didn't ask for this. And well into June, they didn't ask for this. Here we are on the eve of trial, and they're not asking to change their expert. If they wanted to do so, they could have done so then. Prior counsel on the case, Ms. Williams, when she got the case, she hired Dr. Schaefer very quickly after getting the case, and they still didn't get a report for 6 months. Not through defense counsel's lack of effort in getting that, it was just Dr. Schaefer didn't turn it over. I can understand why they want to change their expert. If they want to do so, they've had 6 months to do it. They still have, from my count, 21 days. We are 3 weeks from jury selection. We're still well within the 10-day limit for the state. They can go ahead and do that sort of thing. As far as the DFACS records that we got up, we got those DFACS records a handful of weeks ago. They are largely duplicates of what was already turned over. The significant portion of those documents relating to the defendant and her history were already turned over, already examined by Dr. Schaefer, already examined by the state's expert that we hired back in February for this. That is something that they could have done. They simply chose not to.
So the state's position is that the vast majority of the DFACS records that were turned over, let me say, about 3 weeks ago, are duplicates that have already been available to everyone.
Yes, either the documents themselves or the information contained therein. They are information that was out there long in advance, things going back to the history of the defendant in relation to her interactions with DFACS.
The defense and state approached me in chambers with a stack of letters. I have read each of these, and I want to say I greatly appreciate y'all getting them to me ahead of time. I know some of these are from I think I have 2 separate grandfathers that wrote a letter, grandmother, several family friends that were in here, some that have been lifelong friends. There were also a couple letters from people that just met Miss Patrick after the incident. There was one that was very kind, even said, Judge, I don't envy you and the decision you have to make and the weight of that. So that person, I appreciate that as well. I say that just to let you know I did read these. And I picked out one in particular that said that so that y'all know I did read these. And they do matter. No matter what the decision is that I make today, these letters do matter and they have been read and considered. All right, State, you ready as well?
State's ready.
All right, defense, is your motion.
Thank you, Judge. We are here just for the record on a motion.
I didn't realize that it actually ended and it went to play something else. That was really weird. So the defense on July 13th asked for a continuance because they have this new evidence that they've uncovered that this possible firearm was pawned by another person, and the investigating law enforcement, didn't disclose that. So absolutely, they asked for a continuance. It was denied. Then as they get set for trial today, apparently they again renewed their request, and a trial was continued.
We have some breaking news.
Let me just play this. So we just found out probably like an hour ago, but here's some more confirmation.
Regarding the trial of Sarah Grace Patrick, that's the Carrollton teen who was set to go to trial this week for the murder of her mom and stepdad. Well, we've just learned from our reporter in the courtroom, this trial has been delayed. They will have a new date set by the end of this week, but Sarah Grace Patrick will not be standing trial this week for the murder charges that she currently faces. She was 16 at the time that Kristin Brock and James Brock were killed in February of 2025. She's now 18 years old. That trial was scheduled to begin with jury selection this morning. Potential jurors at least, were called to the courthouse, and we were expected to go through voir dire with the attorneys, a process that could have lasted all day, perhaps into tomorrow, and then we eventually get into opening statements, and then a lengthy, potentially days-long trial before we get to closing arguments and eventually a verdict. But, well, that can's been kicked down the road. It's going to have to happen a little bit later. The attorney, Sean Hoover, had in recent weeks argued that new information is coming to light in the case that they need time to process and prepare for, asserting that what appeared to at first be small issues they want to address into something that has snowballed into something bigger. So perhaps the judge was given that evidence from attorneys on either or both sides this morning, and for whatever reason, we're still working to learn, the Sarah Grace Patrick trial has been delayed. She will not be standing trial this week. We're digging into that story, and we'll bring you updates today on 11alive.com and here on 11 Alive streaming.
All right, so there you go. What was supposed to be jury selection today has been pushed to next year, with possibly finding out about it later this week. We'll find out the schedule, and we'll give you an update as we can. Cuda Girl says, I know before she was arrested, she was loving the spotlight that was on her and the crocodile tears. I feel awful for the younger siblings. Yeah, especially the one that found her parents. She was like 5 years old at the time. Shannon, thank you so much for the 10 hiding jewels. Thank you so much for that. Debbie, I agree with them pushing it after the last hearing. I agree too. I didn't watch that hearing until just now with you guys, but I read the headline, and it did seem like, and now actually after hearing it, she deserves to have her due diligence, and it makes sense that this is pushed out at least 6 months. Let her defense do what they have to do to make sure that this is a fair trial and she gets a fair trial, and we don't want anything like that, because then of course appeals would happen, and it just would and if it was found, if she did win her appeal, then we'd have to go through it all over again. So it just makes sense. It just makes sense to push it down the road. Ignore me, don't care. How are you? All right, let's see. Yeah, Debbie, she should have a fair trial. Kathy, what happened with the Only Girls fan? That's Courtney Clenny. She took a plea deal, so that's actually next week. That's actually the 10th, next Monday. We will cover that. She took a plea deal. We're not quite sure what that plea was, what that entails. So we are going to watch that, and I hope that you guys watch that with us. I invite you guys to watch that with us. That's Courtney Clenny out of Miami, Florida, and she took a plea deal. She was supposed to go to trial later this month. We had all these trials this month, you guys. We were going to watch Sarah Grace Patrick. We were going to watch Mario Fernandez. He's still on. We're going to watch Courtney Clenny, and Courtney Clenny's took a plea deal, and then now Sarah Grace has been pushed down the road. So we still have Mario Fernandez coming up. And we're not covering Lindsay Clancy. We made a decision yesterday. I don't know if you guys were with us. If you guys were with us yesterday, we did a week one recap, and YouTube demonetized us. for that stream. So they're still showing ads, but we're not making money off of it. So no super chats. You could still do gifts. You guys could still give us gifts, which was nice, or give the channel gifts, which was much appreciated. But at the end of the day, we spent 7 hours and we made 5 cents. So not that it's all about the money, but we also have to look at that in that regard to see we spent Saturday putting our deep dive together, our what we were going to do for week 1, and then we spent like 7.5 hours watching, and then only to be told that, you know, we literally made 5 cents. And again, it's not about the money, but it also just is like a kick in the gut. When I would refresh and I'd come back in, it said, make sure that you're 18 years old. We got an email saying, are you guys okay? Are you guys safe? So we're like, it's just not worth it. I don't know. It's just not worth it. So if you're looking for us to do further weekly recaps of Lindsay Clancy, we will not be doing it. So we're going to move on. So with all that being said, that's it. So that's all I have for you guys right now. I have a redirect. We're going to do Ego Takes the Stand with Afro Man. That's coming up, I think, at 12:30. I have it scheduled for 12:30. I think I have it scheduled for 12:30. So I was planning on just taking a little break, feeding the cats, having some lunch. So this week is weird. This week is weird. I found something for us to watch tomorrow. Possibly it could take 2 days. So until the next live trial comes up, I'm going to explore this a little bit further, and then I'll let you guys know. But we'll do that tomorrow. So we have Ego Takes the Stand with Afro Man coming up at 12:30. So until then, thank you guys. Grampy, if you're out there watching, I got your girl right here, Super Ball. Yeah, it's a good girl. There you go. Oh, it's my good girl. Yeah, it's a good girl. Yeah, I know. Tell me all about it. All right. The Tempes Cuda Girl. I'll have to look more into that. I'll look more into that if there's something. I'm not familiar with it. I'm not familiar with it. I mean, I'm familiar with it, but I'm not sure where it is right now. So, all right, you guys. Join us at 12:30. We're going to watch Ego Takes the Stand with Afro Man. There has been an update on what he's doing, so I think hopefully you guys will appreciate that. All right, thank you to our mods, thank you to Aaron, and thank you to you guys for watching. And we'll find something for you to watch, I'm sure. Well, next week will be Courtney Clenny, Mario Fernandez. His jury selection starts next week. So like the next 2 weeks, we kind of have to look around because we were hoping it would be Sarah Grace Patrick for 2 weeks. So we kind of have to look around and find something for you guys to watch. So, and we will. So with that, take care, and hopefully we'll see you at 12:30. Okay, bye.